My learned friend Mr. Omari has not admitted, and I want that to go on record, that indeed there was a road named under or in the name of the first gentleman. What he's saying is the governor in our wisdom is allowed to do certain acts, but in this case we deny that there was any naming of a road. I was expecting the move of this motion to table evidence before this court that are in tandem with our statutes on how a road has been named. When I walk along the Meru streets, Nairobi streets, and any other street, there are clear signages that indicate Jorincheke Street, Moi Avenue, Tomboya Street. I invite the mover of this motion to show me one signage that reads Mureiga Baicho Road. None. So how is it that we are talking about naming a road that has not even been named at all? Where is that signage? Where is that instrument in the hand and seal of the governor naming that road, so that then we are able to accuse her of breaching the law? A Facebook extract is what was produced. The governor states that that was just a humorous comment on social media. Does that constitute an executive order? Does that constitute a government directive? It does not. So we cannot then rely on social media extracts and then accuse the governor of having done or not done a specific act. Let that be clear. And I was expecting the mover of the motion to be able to do that. The other issue that I want to address before I go to my closing remarks is the issue of contempt of assembly. And allow me state this. This particular count does not exist under our statutes. I was expecting the mover of the motion to show us which particular standing order, which particular statute, which particular provision of the Constitution the governor breached by failing to appear before the House Committee. And at what point does failure to appear before House Committee amount to contempt of assembly? My understanding is that the governor was invited. She responded through a letter requesting for interpretation and proper application of Article 175 and 195, whether the Speaker can indeed summon a sitting governor. There was no response from the Speaker giving directions on whether it was provided for under the law that the governor could appear before the House Committee to answer to charges. In a proper setup, when there is a response to a summons, the person then who initiated the summons is expected to respond to that particular complaint or concern that has been raised.
Council Mutuma, please.
Yes.
Please allow me to inform you that the first letter that summoned the governor was signed by the Speaker, and nobody else has the powers to write a letter to the governor except the Speaker. In the first instance, the letter that I received from the governor stated very clearly that the governor was attending a meeting convened by His Excellency the Deputy President. A reminder that I wrote again the second letter requesting the governor to appear to the committee. She said that she cannot appear to the committee. So generally, she gave two contradicting letters. And I believe by the time she wrote the first letter, then she must have consulted the lawyer. So please bear with us on that. It is clear, the way she wrote the letters, she knew that she's supposed to appear before the House Committee.
Thank you very much, Mr. Speaker, sir. In my usual duties, when the court summons, you fail to appear, what they do is to issue a warrant of arrest. If you then respond to summons, giving an explanation as to why you cannot appear, then there is a determination on that issue. Mr. Speaker, sir, what then we expected is that once the governor raised the issue of